way of information has a date range of January 4th of 2022 through February 16th, 2022. At some point later, Mr. Fernandez was arrested and he was indicted. And in his indictment, the government alleges that Mario Fernandez's date range of his conspiracy is November 1st, 2021 through February 16th, 2022. Later in procedural history, Shanna Gardner gets indicted, and her date range of the conspiracy is May 1st of 2015, approximately 6 years earlier, through March 16th, 2023, sometime after February 16th, 2022. And certainly, by way of being involved in this case, going through the litany of discovery, I can, I suppose, figure out what some of these dates are. For example, February 16th, 2022 is obviously the date of the homicide. There are certain things that are known by way of just being involved in the case and basic discovery and just being a competent lawyer. However, there are other dates where we have no idea. And I believe that the law would suggest, and although I can see the court has great latitude of controlling discovery, but that the defense should not be left to guess as to what some of the other dates that are so significant that they start or end a conspiracy, which of course is an agreement between two or more people. So obviously, Mario, Mr. Fernandez, is not involved in the conspiracy that starts in May 1st, 2015 until alleged November 1st, 2021. In the facts of this case, he doesn't even know Shanna Gardner until approximately 2018. So there is some other unindicted co-conspirator at some point who has not been arrested, who's not been identified, and I should not be left to guess who that is, and then certainly should not be left to guess why on May 1st of 2015 that day was chosen. What happened, what act, what agreement, what fact starts the conspiracy and with who. And then on November 1st of 2021, it's alleged that Mr. Fernandez joins the conspiracy, and our team does not know why. What act or fact or agreement on November 1st, which of course doesn't coincide with when it is alleged that Henry Tennant, the third arrested co-conspirator and information filed co-conspirator, who joins the conspiracy on January 4th, 2022. They all three have different dates to start, and two out of three have different dates. One out of three, has different dates than the other two for when it ends. And like I said, obviously some of these dates are so obvious that it doesn't need great explanation. But many of the dates, especially the beginning of the date, and who the unindicted co-conspirators are during the date ranges in which one conspiracy has not begun and another conspiracy has ended. And we would argue that the indictment of our client, Mr. Fernandez, is wholly void of that information, and we believe we shouldn't have to guess or go fish or sift through mounds of discovery. And even if we do, and we don't necessarily, may never uncover it. We don't know what it is. So that's what we're specifically asking for, is what fact constitutes the beginning of the conspiracies, who the unindicted co-conspirators are during times of the conspiracy where Mr. Fernandez is not involved. And I believe that we should be entitled to know that to prepare for trial, depositions, and our defense.
Okay. Let me hear from the state.
Judge, the state's going to ask the court to review some case law, provide the citations. Baxter versus State, 586, 7th, 2nd, 1196. State v. Mena, M-E-N-A, 471, 72nd.
471.
471, 7th, 2nd, 1297. Your Honor, just regarding a statement of particulars and those regard conspiracies and unindicted or unknown co-conspirators. In regards to statements of particulars in general, the state would cite, I'll cite some cases at the end. Obviously, this is within the discretion of the court. It's a matter within the sound discretion of the court. It's not a legal right for the defendant, but it depends on the circumstances, whether it is necessary for the defendant to prepare their defense in this case. The state has alleged, and we are only halfway through depositions, based on physical evidence, digital evidence, and the anticipated testimony of witnesses at deposition, a variety of date ranges for an entering a conspiracy. Within the indictment, we have named specific co-conspirators as it applies to Mr. Fernandez. If Mr. Dreiser is talking about what he believes to be inadequacies in the charging of Ms. Gardner for time periods in which she's conspiring with other individuals, which the court has heard some evidence of at her bond hearing, those particulars have been made known to her defense team at the bond hearing, and her information and discovery do not prejudice the defense for Mr. Fernandez from preparing a defense in their case. I believe it's properly pled. We're not asking them to guess. We are not required to reveal our theory of the case. There is sufficient discovery through depositions left to be done that I believe this is not ripe at this point even. I believe that this information is discoverable through regular deposition schedules and regular review of the discovery provided by the state. A conspiracy on its face is a fluid and flexible allegation, unlike, say, a particular act, a one-time act such as a homicide. With a conspiracy, there is a date range. There are various locations in which it happens. There are various individuals. So asking the state to lock itself into providing specific acts and statements outside what is already discoverable through the process in which we're engaging, I believe prejudices the state's ability by forcing us to tip our hand as to defend our state theory of the case to defense. I don't think it's necessary based on where we are in the discovery process and depositions at this point. I'm happy to reconsider it at a later time if once they've spoken to witnesses, once they've reviewed the discovery, once they've deposed co-conspirators or co-defendants. If they still believe that they are prejudiced, they can readjust it with the court at that time. But I don't believe at this time this is a ripe issue for the court. I don't think that they are prejudiced in their preparation. I believe it's properly and sufficiently pled in the indictment for them to conduct necessary discovery and depositions, and I believe requiring the state to line by line point to specific statements and evidence at this point in the case would prejudice the state's preparation. It has not much to do with this motion, but at some point the state is going to be filing motions regarding admission of co-conspirator statements for the court to make rulings on pretrial admissibility. And at that point, that would necessitate that many of these questions will be answered following the discovery process and the depositions of some of these witnesses and further discovery on the part of defense through their review of what's been provided.
So, I mean, obviously I haven't read these cases yet, but I will.
I have not either. They were not provided to me.
Do you want some time, do you want a moment to look them up? I was gonna try to look them up.
If we have enough time, if not, I could do a written response if I felt it was necessary. But I just wrote the sites down. I have them up, but
Okay.
I know we're limited on time.
I know. I'm sorry. Okay, so I'm gonna table this for a moment. I was looking at the rule. I'm gonna try to read those cases. Let's move to the second, so I know where the issues are. And then
The court,
the
I
motion
had
to
some
issue.
response, but if the court doesn't feel like it's necessary, I can move.
No, I do. I'm not, I can't think about it until I look at what was just
Okay.
given to me, okay? So let's table that for a moment. All right, let's move to the second motion.
Your Honor, on behalf of Mr. Fernandez, the defense has also filed a motion to issue interrogatories to co-defendant Henry Tenen. Mr. Tenen is now a cooperating witness, as the court knows, and Mr. Tenen gave a 5-hour interview to law enforcement when he was first arrested. Nothing, not one really single fact that he gave in his voluntary interview with detectives is consistent with now with his sworn statement that he's given. Mr. Tenen denied being at the scene. Mr. Tenen denied having any involvement, having any knowledge. Sometimes being in Jack's Beach, sometimes he admitted he was in Jack's Beach. But albeit not one single admission to the crime that he is now alleging that he participated in and has given a sworn statement many, many months later. As this court may or may not know, I was provided with the sworn statement, the audio. We've since had it transcribed, and we have limited information as through yes and no, primarily a question and answer format as to what he says his involvement is now. This case, as you know, ad nauseum at this point, is humongous. The cell data, it is overwhelming with the amount of data they have on different individuals like Mr. Tenen, like Mr. Fernandez, like Ms. Gardner. We have obtained, we consult with an expert, we map calls, we do things in preparation of our defense, and the state does the same. They provided us FBI Cast Agent Blythe, who is mapping and routinely providing updated discovery as to the work that he's doing, for example. The financial records in this case are so voluminous that, of course, as you know, it wouldn't blow your mind at this point, but it would blow a normal circuit court judge's mind of how many bank records there are, how many months, how many different accounts that the government ascertained. So, in preparation of Mr. Tenen's deposition, in which we would anticipate that we would want to fact check, document check, consistencies, inconsistencies, you cannot do in real time in this case. In any deposition in which we all routinely take, you're talking about a red well, sometimes you're talking about a disc or some body cameras, and you're either so familiar with it, you can ask questions to push the truth or push back on the truth, depending what your strategy is. In a deposition, we all know that. You could look at a arrest book report, you could look at a photograph, you could look at a Ring doorbell camera, all things that we regularly and typically do, and we do not ask in advance for someone to give us interrogatory questions in advance. But in a case in which there is so much cell data and so much lack of information that we know about what Mr. Tenen is going to say, and given that he is a key witness in this capital case, he's been discussed and talked about, the deposition has been talked about when it's going to occur and how long it's going to occur, and the arrangements. It's a central feature of this entire case. Mr. Tenen gave his information, and then my client was subsequently immediately arrested. He is what I would say the central witness for the government that says that my client is involved and led to the arrest of my client and many, many months after the homicide where he was not arrested. And I provided the questions to the court for your review. These aren't got-you questions. They're not confusing. They can be answered very easily with...
Could I interrupt?
Sure.
Who are you proposing to answer it?
Mr. Tenen via his counsel.
So,
He's well represented.
so practically speaking, so his counsel, this is what you would request, his counsel go to him with these questions. Then he answers through his counsel and gives it back to you. So how is that not in that private setting, essentially setting up his counsel to be a witness if he decides to say something different than what is on the interrogatory, and then therefore creating a potential ethical conflict between him and his counsel?
I suppose it's an interesting thought that you have and being posed to me, but that happens every single day, tens of thousands of times across the state of Florida with interrogatories. We
When?
use them
In a criminal case?
in a criminal case. They're used less often. They have been used. Certainly it's less often, but to answer your question in generality, it no more makes Mrs. Flax a witness in the answering of the questions than it does Mr. Hill a witness in any case in which our office has been served with interrogatories in a family law case, an injunction case, or a civil matter. The lawyer...
Isn't it different in the sense that if you wanted, in those cases, which I'm obviously not an expert on, but I do consider myself very familiar with criminal law.
Sure.
So if someone says something different, and then he denies the paper, or he says something in the creation of the paper that would be the inconsistent statement, the only way to basically attack the paper would be to call the person that was at or around the paper, i.e., like, so let's say Ms. Schlax is like a police officer, right? Like, so you call a police officer and say, I did hear this witness say X, and that is how you would impeach in front of the fact finder.
They're sworn to. So I would use the document itself, not Mrs. Schlax. I
Well,
would say Mr. Tenen, am I the leader of
no. I'm just trying to think this through. So your thought would be, I order his counsel to make him basically make a statement. And so then he makes these statements, then it's delivered to you. He then, for example, I'm sure you had the situation where the witness is like, let's say on the deposition, they're like, nope, I didn't say that, that court reporter got it wrong. How do you say in the creation of that document, you call a court reporter? You can attack through that, or you could, I doubt that any of y'all good lawyers would just let something go like that. If you have the ability to say, call someone and say, no, that document is authentic. Yes, that document is what it says it is. So to me, it's a little bit different than a deposition, because there are multiple people. There's a court reporter there that certifies it. So this is a person that is charged with a crime. This is a person that the defense is, like you said, going to totally attack his credibility. And if he goes sideways on you, not answering the way that you want, the paper may say something different. But if you have the ability to say, let's say he says the creation of that paper is not authentic, then that is what I'm asking you about.
Everything that you're saying is what anyone could say when confronted with an interrogatory in any civil or family law case in which they're obviously used routinely and daily. So
I don't know anything about those rules or those laws.
that's
but
how they're used. You would say, you said on this, you were asked, how much did Mr. Fernandez allegedly agree to you to commit to the homicide of Jared Bridegan? You answered $150,000. Do you agree that you swore to tell the truth? You were sworn in, just impeach him like anybody else. And then I guess if his answer is, I never did that, like that was his I don't know, I was never there. I think that's just a fact for the fact finder to
Well,
determine.
what if it's answered in the sense that my lawyer told me to say that? My lawyer wrote that down. I didn't do that.
Is that your signature? Did you swear and affirm that that is your signature? I mean, and then yes, that's my signature, and then the fact finder makes a decision. They would
So
decide.
you would be willing to say that Ms. Schlax would never, ever be called as a witness to impeach her client?
Absolutely. In this particular case, I have never heard of that. I've never even thought of that. I've used interrogatories to impeach people. I've also never heard anyone say, I didn't answer those interrogatories, but he could. But
I
sure,
don't know.
of course.
I mean, we don't know. And
We
so
don't.
I'm asking hypothetically to think about, like, to me, this is very unusual.
It's not so unusual. I mean, I did not come up with this idea on my own. It's been used in criminal cases. It has the rules, and I think I cited that there is a rule that would give you the authority when justice may require. I don't think these are complicated questions. I don't think they're questions in which a cooperating, I mean, really all of the questions that you're posing to me are almost as if we don't have a cooperating co-defendant. I mean, what Mr. Tenen has said in his sworn statement is, I'm a cooperating witness, I have a deal, I'm going to live by the deal, and in part of the deal that you're offering me, I'm going to testify truthfully. And in fact, as I sit here and say it out loud, I don't know how that's much different at all than what I'm asking. I mean, I guess Mr. Tenen could come in at one point, had Mr. Tenen ever decides that he no longer wants to be a cooperating witness, and he'd be like, that's not me, I never said those things. And then what would the state do? They could call an investigator to come in and say, yes, you did, you were sitting there with my own eyeballs, it sounds like your voice.
So that is exactly what my question is to you, which is, that is what avoids the situation. Essentially, you're requesting the court to compel the attorney for the client that could potentially create an adverse relationship between those two if he were to make allegations towards his attorney. And I know that you are very experienced, and you know that when individuals are either post-conviction and they're convicted of things, they say that their lawyer does this, this, and this, and then we have to have hearings, the lawyer becomes the witness. That is, what I'm asking is, essentially, are we creating that potential situation pre-trial where the criminal defendant would say, I did not get adequate representation, my lawyer did this, this, and this. I understand that you need the information. I have some more questions, but let me pause you and I'm talking, what's the state's position?
Your Honor, the state objects, and for some of the reasons the court has brought up. First of all, procedurally, the rules for interrogatories for civil cases contemplate that interrogatories are between parties to a dispute. So you have a respondent and a plaintiff, and they're sending interrogatories back and forth, which is not the case here. There are factors in consideration that may not be present in civil cases. Number one, Mr. Tenen would have to waive attorney-client privilege to be discussing the facts of his case because he is pled, not yet been sentenced. So the defendant still presumably in that posture, maybe working on mitigation or sentencing factors. He would have to waive attorney-client privilege because he's discussing the facts of his case and potential issues that could be germane to a sentencing hearing with his attorney, and then releasing that information to a co-defendant's attorney. I am concerned about this idea that Ms. Schlax would sit down, ask him questions, write down and Ms. Schlax is a wonderful attorney, no one's saying that. In general, the idea that we're relying on not a witness, but another party putting onto paper what their response is, does cause issues in terms of the reliability and the ownership of those statements by the witness themselves. And yes, eventually, if a defendant is sentenced and does not like their sentence and filing post-conviction motions, the first thing they're going to say is, I didn't say that, she just handed me a piece of paper to sign with whatever she wanted written down on it. The state is prejudiced post-conviction in litigating these issues. When we have procedures to do this, the questions they are asking are questions they would ask within the normal scope of a deposition, and are answers which are outlined in the state's discovery, including his sworn statement.
Well, I mean, and the reason why I'm asking it, okay, so I have two cases that I looked up that reference the rule that you are using, and I'm very familiar with discovery rules, okay? 3.220F, okay? And so I have, let me give it to you. There's a first district case, 351, 7/3, 197, Thomas v. State. In that particular case, the court actually granted kind of like a similar motion. Actually, it was in this circuit. And then I have Bazemore v. State, 7/9, 7/3, 8/28. And actually, let me start there. That's the one. No. I think I can go one case. Hold on. I can go one case. Sorry. Sorry. Dennings, which is Orange County Sheriff's Office, forget the Bazemore case. And it's 158, 7/3, 6/22. It's a 2014 case where the trial court actually granted a motion, and it also has a good discussion on what is material and what is not. And they took the trial court up, the sheriff's office did, on a writ of mandamus, basically where the trial court compelled what I guess the court viewed and abused its discretion in giving over this particular information. So I thought that might be helpful related to like what the rule requires, what material means, and like how trial courts, while we do have like incredible discretion, we must exercise it within the bounds of the law, which 3.220 and F, in my mind, and I hear you, I guess is what I should say at the outset. I hear you, Mr. Drexler, okay, that this case is voluminous, but what I do know, what I'm posing the question, is that essentially the court has had to grant emotional withdrawal for Mr. Tennant already, on one of his lawyers. And what the hypothetical that I am telling you, I don't necessarily know what the conflict is once the conflict was certified, but it's pretty apparent that part of it was that the state of Florida disclosed over notes made by his counsel, and it could be used potentially to impeach him during a meeting. Mr. Chipperfield's notes were part of the disclosure, and then fast forward, here he is, he's got to get off the case. Now, Mr. Tennant is on lawyer number 2. The proposal, I think, by the defense of Mr. Fernandez is running dangerously close and potentially making the Schlats put in the same spot. What he would do, what he would say, whether he would admit, whether he would deny, whether y'all would use a paper, or whether I find myself in a situation either potentially in the middle of a deposition or in the middle of a trial, trying to appoint Mr. Tennant another lawyer because you all are doing everything that you can to defend Mr. Fernandez, and you're going to use every mechanism you know how something that no one is anticipating. So that's why I was asking you the questions related to his representation. So this is my other question. So let me start with this premise. I believe that you are entitled to know exactly, your identification as him to be a critical witness against Mr. Fernandez. Obviously, that's true. What I'm going to ask is this. In the scheduling, you said a red well is generally what you could use. Why couldn't you use the civil type of scheduling on a deposition where you schedule it not just for an hour, that you schedule it over days, that you take a certain period of time, you all take a break, continue the depo. If it takes 3 days, if it takes a week, if it takes 2 weeks, that if you needed to fact check that way, you ask your questions, you fact check, you come back, you ask more questions. You haven't concluded the deposition and you are continuing it. So why couldn't that procedure be used?
It can, I'm satisfied with that.
Right?
Yes,
So, I mean, I don't know why, in criminal law, yeah. You're like, oh, I can take a critical witness's deposition in 15 minutes. This is not that case, but maybe because of the volume, you all schedule it, you all think through. Say, do I need to regroup? Do we need a special room for it? Do we need a TV? Do we need this? All of that can be planned out, all of it can be scheduled, and it doesn't, in my mind, run a very dangerous risk of making his lawyer that is supposed to be guarding his rights a witness against him in any way, shape, or form.
It's fine, Your Honor. If we just may have time on the other issue, I'm satisfied with that ruling and understanding of the court's concern, and we will do it that way.
And if the state, I mean, the rule, to me, the rules contemplate, right? If it becomes unreasonable, the state files a protective order, or Ms. Schlatt's files, and that would be before me. But making her a potential witness is, I do not.
And Your Honor, just for record purposes, that's part of the state's concern. Additionally, I do think that a regular deposition set with sufficient time, sufficient access to whatever they need, should cover it.
Or do you
Interrogatories,
need that?
I mean, because interrogatories used in civil cases.
No, they said
Yes,
fine.
okay.
So it's no on the interrogatories. But as far as how and the mechanism in order to depose him, for them to, obviously I am aware, I know, well, let me rephrase that. I have really no clue, okay, of what y'all are looking at. Absolutely no clue. Y'all keep telling me what it is, and I have absolutely no idea, okay? However, I do understand and weigh the defense's concern that they have a lot of information that apparently doesn't lead them to any ability to defend their client. Because they have a 5-hour interview of him saying nothing, they have a succinct sworn statement by the state, and they have a bunch of terabyte, million computers worth of information. And so with that, I'm gonna send the parties forward, talk away, and you can come back if you have a problem. But as far as like, hey, this is gonna be an hour, Ms. Stifler, you gotta think that's a problem, that's a no, no, okay? You
I don't
need to
think any
think-
of our depots have been an hour.
Okay, I don't know what they are,
So-
okay, I have no idea. All right, I have no idea.
I anticipate that certain depositions will need a significant amount of time and prepared to accommodate that.
I don't know what y'all's depots have been, but, it needs to be thought through in that way, okay?
Understood.
All right.
On issue number 1, would I, if I may ask, to allow us to read those cases, come back for an additional 15 minutes,
Yes,
and then we'll
Like I
square
know
away
what
and
happens.
ruling on that.
we'll table it.
I will, I have a few more cases. I'll send all the case logs that we were able to find as a team to both court and council today, and we can follow up with written responses or oral arguments needed.
Okay,
So,
thank you, and I'm not sure what that basement case was about, so just. Okay. All right,
Can we approach Sidebar for a minute?
Yes. All right. Court series 7.